of the many legal issues that Donald Trump faces, which threaten his finances, his family business, and his freedom, the one that presents the most clear-cut political peril is a case the Supreme Court's going to hear arguments on next week. It is the appeal of the Colorado State Supreme Court ruling that kicked Trump off the Colorado primary ballot for violating the 14th Amendment's ban on insurrectionists holding office. The Supreme Court's decision on Trump's eligibility will obviously be enormously consequential, not least because Maine has also disqualified him from running, and there are similar efforts underway in at least 17 other states. Now, in anticipation of next week's hearing, Colorado's Secretary of State just filed a brief that seems aimed squarely at the court's conservative majority, arguing, quote, just as Colorado cannot be forced to place on its presidential primary ballot a naturalized citizen, meaning someone who is not born a U.S. citizen, a minor, or someone twice elected to the presidency, it also should not be forced to include a candidate found by its courts to have violated his oath to support the Constitution by engaging in insurrection. A. Scott Bolden's a former prosecutor in New York. He's now a white-collar criminal defense attorney. Danya Perry served as Deputy Attorney General for the state of New York, as well as Assistant United States Attorney for the Southern District of New York, and both join me now. Let's start with that argument that the Secretary of State of Colorado is making.
Well, I'm sorry, go right ahead.
Well, just because the state Supreme Court decision by Colorado very clearly was sort of aimed at Neil Gorsuch and aimed at the conservative justices on the Supreme Court because they knew it was going to get Supreme Court review, basically being like, look, this is state, like, what we're doing here is a matter of interpreting the U.S. Constitution, but also state law here. And really, like, you guys are real into the state courts and states figuring out eligibility. It seems like Jenna Griswold, the Secretary of State, is doing the same in that argument.
Well, yeah, and the Colorado Supreme Court wrote this with a conservative Supreme Court in mind. It relied on state rights, and it relied on strict constructionist and interpretation of the statute. That is, Section 3 is self-enforcing. As a former chair of the D.C. Democratic State Committee, I know this all too well because the states control federal and state elections, who gets on the ballot and who doesn't. And so how would you enforce someone keeping them off the ballot, as the Attorney General said, if they had been twice elected president? That would be a state right to decision. The state would not put them on the ballot. And there's nothing really different here, other than they had a factual finding that he participated in the insurrection, if you will. So it's really not different. And there was a finding of facts. These 17 other states that are looking at this issue, some have made findings of fact, or 2 or 3 have. The others have gone through this kind of administrative process. But once you make findings of fact,
in a state court with, again, appellate review and due process and all that stuff.
With witnesses.
Right.
And remember, Trump didn't put on much of a factual defense, especially in Colorado and I think in Maine or some of the other jurisdictions. They've just made these legal arguments that have left them wide open in regard to the Supreme Court and how they're going to interpret it.
And to note, also in particular, you mentioned Justice Gorsuch. When he was sitting on the 10th Circuit Court of Appeals, he specifically interpreted in a Colorado case that a presidential candidate who had been a naturalized citizen actually could not be on the presidential ballot, interpreting the Constitution. So,
and in fact, that very case is cited by the Colorado Supreme Court.
Right. So we'll see these strict constructionists, textualists, originalists, how they interpret this.
Well, I mean, one of the sort of strange things about sort of unsaid here, this is like a great moment for legal realism, right? Because, like, basically what we know is this. The conservative justice Supreme Court are not going to let you kick them off the ballot. They're not going to do it. They know what the outcome is. And now the question is, how do they reach that decision? What legal tool? And I thought this was interesting, Rick Hasen pointing this out, that one of the sort of really narrow arguments that's been made against this section is that it says that, you know, you can't be an officer of the court, right? I'm sorry, an officer of the United States, that the president is not an officer. So Trump leads with a hyper-technical argument. He's not an officer of the United States for purposes of Section 3. They must have calculated a technical argument to be more appealing to the conservative majority than his other ones, such as an argument that Trump had the constitutional right to encourage his supporters to invade the Capitol. So rather than saying, I'm not an insurrectionist, you say, let's not even get into that. I'm not even an officer. A little bit of definitional, like, wriggling out. What do you think of that?
I think it's a tough argument to make, but it does give these justices an escape hatch. There was an interesting amicus brief written by a group of 25 very esteemed historians who, and generally this is the kind of thing that the right-wing group of originalists like to look at.
Yes.
They examine the history of this clause, and they looked at, you know, what an officer means, what that means, and they looked at, of course, the common definition. You think of the president as the chief executive officer, and they looked at, you know, Andrew Jackson, who defined himself as an officer.
Yes.
I mean, it's just hard to
History
avoid.
is replete with examples of the president being understood by U.S. law, both statutory and constitutional, and courts as an officer.
Correct. But as you point out, if this court wants to find a way to get around this, this is a way they might do so.
Come on, guys. Come on, Chris. If the president isn't an officer or the chief executive officer of the United States, which is a government corporation, what is he then? What is he, some agent acting on his own? He's the commander of the military. I mean, that dog won't hunt, as my grandfather used to say. It's just not going to. And the fact that they did not say whether he participated in the insurrectionists or not, as an insurrectionist or not, is a way to avoid that ultimate issue.
Right, but they're gonna have to find some. Look, they're gonna find some way to overrule his decisions. Well, the question is, what is it?
Well, I think what they're going to do, they could make that argument, or they can make another argument that says because we don't know what an officer is or insurrection isn't defined, that it's up to the federal legislature to define it. But there are lots of sections of the Constitution that are self-instructional, if you will, or define themselves. Article 3 courts interpret the Constitution all the time.
That's their job.
And that's the point that Senator Griswold is making, right? Where she says the constitutional amendment that bars a president from seeking a third term doesn't need congressional legislation to effectuate it. It just is part of, you can't make a state put that person on the ballot.
Exactly.
It's self-effectuated.
And it's a state right issue. It's up to the states to do that. One thing to watch, though, and this is completely off topic a little bit, is what does Justice Thomas do? Does he recuse himself or not? And what about Gorsuch? How much does he participate, given his prior ruling?
Spoiler
That's another show.
Spoiler. Clarence Thomas is not recusing himself. And
we got new ethics on the Supreme Court.
No, we do not. We got the same ones. He's got both in it, Danya Perry. Thank you very much.